Hello, welcome back to the pod. I'm Molly, and today I'm joined by Anthony Bally, our CEO, and Joanna Cassens, our Chief Legal Officer. Today, we're tackling a topic that every growing business should be paying attention to: the new UK employment regulations and what they actually mean for you. So, obviously, there's been plenty of headlines and lots of speculation, but what is really changing, who is affected, and what should companies be doing right now to stay compliant? So between the three of us, can we give listeners a quick summary of what's actually changing and why it matters?
This year, 2026, and next year, 2027, are really bringing us a major overhaul of the UK employment law. And there are many changes happening. They will be happening gradually, so they are different timelines. And I just want to mention a few because I think we would be here all day if we were to cover all of those. But I chose some that are the most crucial, I believe, for our clients. The ones that are already being implemented in early 2026 are around changes to statutory sick pay. So the statutory sick pay will be, for example, paid from day one of sickness. Some changes to family rights. So the same with paternity, maternity benefits. They will also be available from day one. There will be a new administrative body to kind of help oversee the implementation on all of these changes. And it will be called Fair Work Agency. And this is also supposed to happen in April 2026. And then we have some more changes coming in October, still this year, about strengthening the anti-harassment rules and prevention laws. And this is a change that we've seen happening since 2024. So employers right now will be even more liable for protecting their employees from harassment, even from third parties, such as vendors, customers. I think the ones that brought quite a lot of excitement are the changes that will be implemented in early 2027, which bring the unfair dismissal protections. They make them stronger in the sense that now the employee will be able to claim unfair dismissal with only 6 months seniority instead of how it used to be with 2 years of seniority. Also, there will be a ban on practices called fire and rehire. There will be a lot of changes around 0 hours contracts, so they will be limited. There is another interesting change which is not related to the Employment Rights Act. It's a part of the finance bill for 2025-2026, but it does apply to payroll providers, their end clients, and recruitment agencies, and that includes EORs. So there will be, starting from April 2026, there will be a strict joint and several liability for payroll related payments towards employees. So the end client still will remain liable for payroll mistakes, for payroll problems, even though they outsource it to a third party. There's a lot happening, as you can see. So we need to stay very vigilant and we need to start working on a lot of HR processes, on changes to internal documents, actually right now, to be able to meet the deadlines.
So you mentioned there, Joanna, that joint and several liability for PAYE kicks in April. How ready would you say the market is legally?
So I believe that this change was not that broadly discussed as the Employment Rights Act that brought a lot of attention from everyone. I think that the providers, they've been doing things right from the start. They will have no problems with complying. The providers that don't do the best job with their payroll will have very little time to adapt. And the clients, if they want to rediscuss their contractual terms, which I would advise for any client to do, especially around liability for payroll mistakes, they now will have little time to go through the legal renegotiations of their contract.
And then Anthony, same to you. How ready do you think businesses are operationally?
Regarding the very short-term changes, not sure, but I don't think that's the major one, as Joanna was explaining. In general terms, when you have changes like that, companies are never ready. They're always playing catch up. By the time they realize, they hear about it, they understand the complexity, they've got the resources. The harsh reality is that bigger companies are more ready because they've got more resources, again, more people who are monitoring those type of things and taking care of them. But for our mid-market clients, it's unlikely they're going to be ready. Of course, a lot of the things that we do are essentially supportive of those clients. So us as an EOR, we can, especially with our consulting type of approach, we can drastically help our mid-market clients.
Cool. And If we were to look at the bigger picture, what does this wave of regulation signal about where UK employment law is heading? Are we catching up with Europe, or are we going our own way?
I think that I would call it catching up with Europe. This latest shift is very interesting, especially for lawyers, because in Europe, we've always had two different legal systems coexisting. We've had the civil law system in continental Europe and the common law system in the UK. They are fundamentally different from one another. The civil law system is based on codified regulations passed by the parliament, which are very specific. They are very extensive in regulating our reality. While the UK common law system was based more of judicial discretion on case law, so it was kind of more of a living organism. And I think that the decision to implement so many changes to the entire employment law system in the UK via a legal act such as Employment Rights Act, it brings the UK closer to continental Europe. It leaves less judicial discretion. All of these changes are not based on case law. They will be based on the act that has been passed by the parliament. So I think that UK is catching up to continental Europe. Also in general terms of stronger employee protection. So continental Europe is and has been known for that. And we've always had that belief that in the UK, it's a little bit less regulated when it comes to employment law. And now I think we are definitely seeing the complexity that will follow.
Interesting. So I'm a European company hiring into the UK. Does this change the calculus? Would you say it's an opportunity or a headache?
I would broaden maybe the question. So Europe versus UK, I don't think it's going to change too much, because European countries, especially further south, are used to even more stringent protection of employees. So for them, it's just like business as usual. It's even easier. So the reason why they used to employ UK will not change. Those changes will not be a hurdle for them. I think it might have a slight positive impact on the UK to Europe, because obviously for a UK employer, the gap between employing somebody in a country I know very well, France, versus UK, is narrowing. It's not quite there at all. It's narrowing in terms of the protection of employees. If we take a step back and we broaden that question to more US to Europe in particular, which is like a major route of employment, I believe that in the long run, that can have an impact, because historically, you have the US in terms of whether that's in terms of progressive aspects or openness to market. You have the US, then the UK, then the rest of Europe. And for a US company who wants to go into Europe, the natural step, not only because of the language, but also because of the regulation, as Yona was explaining, is closer. It makes a lot of sense to start by the UK. So you want to establish yourself in Europe, you start in the UK. As those taxes are catching up with other countries, as those regulations are catching up with the other countries, that will become a little less obvious. So that'll be interesting to see how that unfolds. It's not going to be overnight, obviously, but that might have an impact on the longer term in terms of the appetite from non-European companies to come employ into the UK.
Mm-hmm. And what would you say this means for the reality for HR leaders? As we know, we work with them every day. Most HR leaders are juggling direct employees, contractors, EOR workers, and agencies. How did these changes complicate the picture?
Well, the reality doesn't really change the big picture, but it just contributes to the complexity. So we discussed in another pod, I think, around the spectrum of needs that our HR leaders across companies have, and you listed them, like from contractors to payroll only to EOR to establishing legal entities. But I think the common denominator is the change. So whichever the country and whichever the segment of those employment, changes are happening all the time, and they are faster and faster to implement. Of course, the impact is an additional layer of complexity. I don't think it changed. That peculiar discussion we're having today about the UK changes does a massive change. But I think it, and maybe that's good for our business, I shouldn't be saying that, but it basically pushes further HR leaders to be seeking expertise where it is, where they can find it. And in the case of the different type of employment we were speaking about, Teams is very well placed to provide that expertise, especially through the consulting approach we have.
What do you think HR leaders should be asking their legal teams?
So I think as a first step, when it comes to the changes around liability for PAYE, I think that they should definitely ask their legal teams to review the contracts with their current providers if they use external providers, and they should renegotiate the liability around payroll and payroll mistakes. But I also think that generally the HR teams are heavily burdened. So they are the teams, especially in the mid-market company. They need to take care of everybody else. They need to establish well-being programs for others. On the top of that, they need to catch up with all of these changes that are happening. They need support themselves. I think that the legal team should be there to support them, especially with reviewing their internal policies, seeing if these policies now illustrate the new reality correctly, reviewing the biggest risks that they can encounter before it's too late, thinking about how they are going to approach the unfair dismissal claims in the near future. I think that the legal team support is very important. It's a lot of burden for the HR teams that are already juggling so many other things at the same time.
Yeah. And so with that, what do you think will keep people up at night? Obviously, you've got 6 years of holiday pay records, criminal penalties, 15% rise in tribunal claims. What do you think will worry people the most?
So it definitely depends on what profession you are. For me, as a legal professional, something that would keep me up at night is the risk of tribunal claims, because that's something that we cannot budget. We almost never can predict. When we get this claim, then we have very little time to work with the claim. We have very little time to mitigate the risk. I think these are the things that would keep me up at night, because they are the least predictable ones.
And so looking ahead, if we're back here having this conversation 18 months' time, what do you think that we would be talking about? What do you predict?
So I think the best answer would be, I have no idea, but because we can have a lot of new things coming in between. I think that especially in the European employment law landscape, there is one single truth. That truth is that the change is the only constant. So the only thing we can be sure of is that things will be changing, and they will be changing fast. So we need to proactively face these changes. And on top of all of these employment laws that are changing constantly, we have additional regulatory changes and burdens coming related to AI usage, especially in the European Union, related to platform workers as well. We will need to be very vigilant, and we will need to just keep addressing these changes as they come. As a side story, when I started studying law many years ago, I got a book from my uncle, and the book was from 1997. And I knew that the book was outdated to a point, but I still felt quite safe using this book to consult on employment law cases and on the rules on how to approach different legal problems. Right now, in the reality where we are at, I would never dare to use a book from 1997 anymore to consult any of my legal problems, because things are changing way too rapidly.
So if you had to write a book now, because things are changing so fast, by the time you published it, it would be out of date already?
There is a high risk that would happen.